So, since October is Special Needs Planning Month, I figured today we would talk about special needs planning, what it really is, and who it applies to, and what types of families should think about it seriously and implement planning for themselves. So, special needs planning generally refers to the maintenance of means tested public or government benefits. Usually, we're talking about SSI and Medicaid, but it could also be state based benefits like food stamps or supplemental assistance, or generally other resources or agencies that provide resources to disabled individuals, whether they be children or adults, and maintaining eligibility for those benefits because those benefits are generally means tested, meaning that you must be poor in order to receive them. So while disability is a threshold requirement, the person has to be disabled to the point where they can't support themselves, they can't achieve what's called substantial gainful activity if they're an adult, or they have marked or severe impairments if they're a child that essentially will not resolve themselves for a period of 12 months or will result in death at some point. So there are really two rungs to the eligibility piece here. So SSI and Medicaid both require those sorts of disabilities, but also that a person has a certain level or below a certain level of assets. So generally that's $2,000 per individual or $3,000 per couple. So what that's really talking about is countable resources. So countable assets are generally things other than a personal residence, one vehicle, those sorts of things that are required for support and daily activities and those sorts of things. And really, it relates more to liquid accounts, cash, things that can be converted to cash quickly, those sorts of things. Essentially, the end goal being that if you have these sorts of assets, cash and cash equivalents, that those should be used for your support first, and that Medicaid or SSI should be the payer of last resort for these sorts of stipends or medical benefits and those sorts of things. So what special needs planning is essentially attempting to do is to maintain and preserve those benefits in the event of an unexpected inheritance or gift to the beneficiary of those benefits. So the way we structure planning is to make sure that an inheritance or a gift is going to a beneficiary's trust or 529A or ABLE account instead of going to them directly, so that those assets that go to them, whether that be by inheritance or gift, are not actually received directly by or available to that beneficiary. They're essentially being held for that beneficiary's benefit, either by the trustee of the trust or a guardian on a 529A account, which 529A and ABLE are synonyms. They're essentially the same thing. So I'll use those interchangeably throughout today's episode. But generally what we're trying to do is preventing the outright gift or the outright inheritance of assets to the beneficiary directly, so that those assets are not available for the purposes of counting against that $2,000 limit. So what that looks like is structuring a special needs trust for a disabled beneficiary, or setting up a 529A account for that beneficiary. Now, again, these are only appropriate to the extent that the beneficiary needs to preserve those benefits, which generally, if a beneficiary is on those benefits, they are worth preserving, which means that there are no other resources that can support or private pay for the needs of this individual. So generally, if this individual is a beneficiary of those benefits, they're worth preserving. So special needs planning is absolutely important and should be implemented for any family that has a child or an adult who is receiving SSI or Medicaid or any of those other public means tested benefits, that uses those benefits or needs those benefits for sustaining their daily life, right? They can't maintain their daily life without them. So if you are a family who has substantial means, has a high net worth, and can potentially afford to private pay or self-fund the treatment for this individual, then special needs planning may not be the best result for you or the best path for you, because the nature of ownership in special needs planning is in a protected capacity, one where the beneficiary, the individual, does not have direct access to these assets. So if they don't necessarily need to preserve means tested benefits, it would be a disservice to them to put those assets in a protected capacity that deprives ownership, deprives full use, uh, because otherwise that person could, pay for these things individually or pay for things over and above what they would normally get from SSI or Medicaid, and rather instead of those types of benefits. And it may be in the person's best interest to allow them to have free reign or full access to those assets. And that's probably going to be a pretty small percentage of families in that situation that have, millions of dollars or some sort of high net worth that self-funding is possible. But if that is the case, then special needs planning may not be a great result. So if that's not the situation you find yourself in, if you're really thinking past yourselves for what's going to happen to my child after I'm gone, what sorts of resources and access and those sort of things will be there after I'm gone, after both parents are gone, then special needs planning is very appropriate. Not only are we talking about the money management, the asset protection aspect of it, but we can also discuss guardianship, which is essentially getting someone appointed, whether that be a parent or a relative or a third party, to make legal decisions on behalf of an incompetent adult, generally someone who is disabled and cannot make decisions for themselves. So that's another aspect of this, is that we're really talking about the day-to-day for a disabled individual. So one vastly important piece ends up being who will be there after you're gone. So a lot of times I'm working with families who don't have anyone there, anyone past themselves. We have parents of minor children who are disabled, and the worst case scenario or the fear for these parents is that no one will end up being there after they're gone. Generally working with a lot of families who have disabled minor children who, in all likelihood, will outlive any trustee who could be designated to take care of funds for them, or any guardian who may be appointed to manage their affairs or make legal decisions for themselves. So part of that legal planning process is figuring out what sorts of potentially institutional or corporate trustees and institutional or corporate guardians or group homes may be there and may be appropriate choices to help with the day-to-day, to help with the legal decisions and help with the management of assets after the parents are gone or after all the relatives are gone, if there just is no other individual there, especially if there are no siblings of the disabled child. So special needs planning encompasses a lot more than just the creation of a trust or the creation of a 529A. It's actually looking at the totality of the circumstances, the entire comprehensive plan, and making sure that there's a financial piece involved as well. So making sure that we're coordinating with financial advisors and CPAs and making sure that everybody's on the same page, and that the legal aspects are married with and are collaborative with the financial aspects, so that if something does happen, unexpectedly or not, the disabled individual is going to have adequate funding to be able to support themselves throughout the rest of their lives. So part of that piece is working with financial advisors and planning out what we would call a life care plan. So what types of medical expenses they could encounter that are going to be over and above Medicaid, or in the event that Medicaid is lost or is removed entirely. The regulatory nature of special needs planning is that Social Security and Medicaid may not last forever, either by virtue of defunding or just removal entirely. So part of the planning is making sure that there's a structure and funding in place in case there's no benefits to maintain, but that this individual still needs sustenance, they still need support, they still need monetary support to live the rest of their lives, take care of their medical needs, take care of their room and board and the day-to-day things that they generally need. So while on the outside looking in, it may seem that special needs planning is just a way for us to create a trust and everybody's happy and fine and we all go on our ways. But special needs planning is much more about creating a relationship with a family, between the attorney and the family and the financial advisor and the family and all of us together, really collaborating to make sure that the plan works forever, so that it evolves with the family. And so that as any sort of changes in regulation occur, we are tweaking the plan, we're tweaking the finances to make sure that they're still good. They're still going to satisfy the intentions of the plan. So all of this works together. And if you find yourself in that sort of circumstance where you have a child or you have a relative who's disabled and needs to maintain these benefits, then special needs planning is absolutely for you.